with our panel discussion 2. For the next panel, I invite on stage the moderator for this particular panel, Captain Kapil Dev Behel, Director, Indian Center for Climate and Societal Impacts Research. May we have you on stage, sir? Thank you. Inviting fellow panelists out here, Dr. Sanjay Bhabrani, Director and COO, MMS Maritime Private Limited. Mr. Tony Fernandez, Consulting Adjuster for Averages and Maritime Operational Risk Management Advisor. Sir, can we have you on stage? Mr. Amitabh Majumdar, Managing Partner, Bose and Mitra and Company. And Ms. Leena Modi, Average Adjuster, Leena Modi and Associates. So we have a power-packed panel here. And over to you, Captain Behel. Thank you.
Good evening, everybody, and welcome to our session. In many ways, if ever one could define a dream panel, this is one. I'm not saying that because I'm a moderator, but honestly, I've been actively associated with all the panel movements, and this one is really commendable. So why did we select this particular incident, Dali, for lessons to be learned and as a case analysis? The reason actually is that we are looking and staring at a total claim of about $3 billion, which, if it were to materialize, will happen to be one of the largest claims in maritime history, even larger than the Costa Concordia 2021, and even larger than the combined claims of ever given. The grounding in Suez. Of course, that was settled much less. And you know, these huge claims, this case is going on for years, will go on for years, but these huge claims means that the funds are then locked in and it's going to have a huge negative impact on future premiums. So that's the reason we selected this. Now, the way this is structured is that we have lessons we learned in 4 distinct categories. One is of course the legal, and we have Amitabh Majumdar sir to guide us and explain to us the intricacies. The second is the general insurance and general average issues, and we have Ms. Leena Modi to guide us and help us through the intricacies. And then of course we have the cause, the proximal cause, the technical issues, the failure of engines auxiliary, for which we have Mr. Sanjay Bhabrani sir to guide us and help us. And last but not the least, we have the Maritime Operational Risk Management, which is a major concern here, and we have Professor Anthony sir to help us there. So we were supposed to begin immediately, but I thought to myself, perhaps, and I'm sure everybody is familiar with the Dali incident, but it would help to recap the sequence of events, so that as we discuss, your memory is sort of recovered in terms of what happened, so you can understand the opinions better. Can we have a quick? There are few slides. Can we have a slide, please? So the first thing I want to just say is the disclaimer out here, and if you can't read, I'm reading the panelists. Neither have personal knowledge of this. We really have picked up everything from the public domain, and like I said, the matter is still in court. So now this is really, to be taken as gospel truth. We are giving our opinions and trying to guide through this maze. So the presentation is prepared from newspaper reports and from website reports. Next one. Next slide. So I just wanted to go through the second one. So essentially, just keep this in mind as we go along. First one is a general description of Dali. So you have here the size. To give you an idea, you have the main propulsion and the electric power systems. The size is important. Then we have the flag and the club. Let's just give you an overall view. So please keep this in mind as we go along. The next one. And here is the bridge. So the key thing to remember is the Pier 18 location, the Pier 17, and the dolphin that's marked in yellow, and the fendering system, of course, and the general layout of the bridge. The next. So here you see the type of truss that is being used and the multi-beam girders, and you can see now that the ship was trying to move past between 17 and 18. Next. This is the chart of that area, the last one, previous one. So effectively, you can see the berth from which she finished the cargo movement and then took a turn round, and then she was heading southeast till under the bridge when the accident happened. Next. Keep this diagram in mind, although Sanjay ji will actually allude to this again, but keep this in mind because we are looking at a gap of just 2.5 minutes between the first alarm, the blackout, and the illusion. So it's going to be happening very rapidly after that, but keep this diagram in mind because this helps you to understand the last one. And this to give you an idea of how the salvage operation was carried out, the size of the cranes, and the remarkable fact is, despite all the problems, they managed to clear the second channel within a month, the US Army Corps, and they actually got the second channel, and the vessel then absolutely freed of all the debris and refloated within another month after that. So very, very commendable efforts by. So thank you so much. Let's begin now with our discussion. So like I said, we have 4 issues here, and each of these panelists will be addressing one particular one. So legal is what's coming to my mind first. So Amitabh sir, the limitation of liability regime is enacted essentially to encourage trade, encourage commerce, shipping, investment. So the Convention on Limitation of Maritime Liability is not 1976. That's not valid in UK. USA, they have their own convention. So in about 15 days or 20 days after the incident, the owner filed a petition in the court there to limit their liability and cap it to the ship's value plus value of the freight. So how does this, with reference to the ship owner, how do these two conventions differ between the Indian and the, or rather the rest of the world and the US one?
So thank you first of all, Marex, for having us. It's very different because the US is not party to the convention, and they have 1851 Act, and as you correctly said, it is to the value of the vessel and freight, and that would be what the cap would be. But of course, with as was with the earlier, before the 1976 convention, you could break limitation in such events by trying to prove whether there was negligence, etc. The advantage of the convention countries of the 76 convention is that breaking limitation is very difficult. And of course, the convention countries, the limitation is much higher. In fact, we had the 1976 convention, and then you had people who were party to the 1996 amendment. India is a party to that. And then whoever was party to the 1996 amendment was also a party to the further amendment which took place and enhanced the limitation. And you're absolutely correct, it gives certainty. It gives certainty that if an incident takes place, how much is my liability? What is the financial? As I said, today it may go on for another 10 years, and if there's $3 billion which is stuck there, then there is uncertainty, because at the end of it, it could only be $1 billion, and then you've got $2 billion coming back to the market. So for example, for a ship of Dali size in India, it would have been a $175 million limitation of liability. In America, it would be the American law. In fact, the American system is such that they had tried this, I understand, during the previously as well, but it was unsuccessful. But they've now again put up a bill to try and increase, with a retrospective effect, limitation of liability to being 10 times the value of the ship. for only foreign ships. So, that's America. But yes, there is a huge difference. But of course, again, depends on country to country. The Vidali was a Singapore flag vessel, so they would be entitled to limit liability if something happens in India.
Thank you, sir. So, Ms. Leena, we just heard the huge volumes of claims involved. For our delegates, for all of us, can you please enumerate some of these claims, of most of the claims, and categorize them for us?
Thank you, Marex. Whenever there is a claim, we first look on insurance. And it's an altruism known to all that without claims there is no insurance. So, yes, you can broadly classify this claim from common man's perspective into 5 categories. One is the physical loss or damage to the property, which also includes the bridge, vessel, cargo, containers. Then there is the cost of recovering the damaged property, which we call salvage. So that is the second one. That's the salvage operations which were carried out to remove the parts of the bridge as well as to remove the vessel from there. Then there is the loss due to delay. There's a lot of loss which will come as a liability because of delay in opening up of the channel, delay of the cargo on board the vessel, delay of the ship. We'll deal with it in particularly if we get time with each of them. Then there is the business loss or the business interruption loss and the loss of profits. So the vessel is held there, there's loss of profit for that. There are so many vessels which were stranded, which could not come out of the port for many days. There were so many which had to go in, were stranded outside the port limit. And so that's a business loss. And the last is the legal cost. So these are broadly the 5 categories on which the loss would fall. And the various other insurance policies which cover some of these losses. And some of them are not covered, or the owners will have to deal with it. That only time will say how much liability will come on the owner, how much he could limit it. It's only a matter of time, it's in the court, so we don't know that. Numerically, various figures are coming up, but only time will say that what would eventually be the owner's liability.
Thank you for breaking this down for us, because this is important for everybody to understand as we go along. Sanjay ji, so before I go to the actual technicalities, when this incident happened, my first reaction was to search on the internet for precedents and board the ship. And Equasis.org mentioned an incident which had earlier happened, in which they mentioned a deficiency connected to the main engine and auxiliary engine failure. And then, to my dismay, I found that 2 days before this incident, 2.5 days before the incident, there was another blackout, and soon after another blackout. I mean, within a couple of minutes, I think. So my concern is that, and that's my question to you, sir, these 2 separate incidents and the final one leading to the allision of the bridge, are they in any way similar in nature in terms of causation? That means, sir, can somebody say, see, look, the ship owner knew, why did you leave the port? So, in a broad speaking, was they similar?
Yeah, I think first of all, my thanks to Marex for inviting me over and allowing me to share my views. Secondly, now coming back to the question which has been raised by our respected moderator. Yes, there's a finding which is listed on the Equasis.org, which says that sometime in the month of June 2023, there was an observation which was noted by one of the PSC during one of the PSC inspections. Now, if we were to look a bit further than that, we find that the same observation was cleared on the same day. So essentially what really happened was that it was an observation which was given and it was also cleared up almost immediately. So there is no reason to believe that there is any kind of a residual aspect of that observation which was remaining all the way till the time this particular incident happened. That is number one. Number two is the overall sequence of the events which took place when the vessel was alongside, when she was there at Baltimore port. Now there were indeed 2 blackouts which had happened. Now, yeah, I want to just highlight one thing very clearly, that we are not really aware of what really happened. So our reference is going to be the report which has been released by the National Transportation Safety Board dated the 14th of May 2024. So everything is going to be based on that, and essentially I've been given the brief that I need to focus on the main technical aspects. So my job will be to try and demystify that report to the extent possible, since I have this kind of a technical background. So I'll just try and see how we can demystify it. Now, so again coming back to the point that that there were two blackouts. The first blackout, as per the report, which says is that there was an exhaust valve which was closed. So because of that, the exhaust gases were not able to move out, which resulted in the engine stalling. So then this is something which is absolutely unrelated. Secondly, there was a standby generator also, which was started, as all of you would know, that if one generator was to trip, there's a second generator which is kept on standby. The standby generator also started, but however that generator also tripped because of the shortage of the supply of the fuel. Now the report is not really saying why it really happened, but that probably means that it was more of an isolated event. There is no way to link that up with what actually happened later on.
That's reassuring. Thank you, Sanjay. That's reassuring. Tony sir, Sanjay just mentioned about the NTSB code. So we have this IMO Maritime Casualty Investigation Code, but then that is applicable for incidents in the international waters. Here, of course, the US has territorial jurisdiction for criminal and civil case courts. And like he said, the NTSB is mandated to carry out the investigation. So this investigation essentially is now to find out the root cause. So sir, from your experience and perspective, keeping in mind this background, what is the operational risk management that can be learned from this for our future?
Tony, thank you very much. Can you hear me? Okay. Marex and your team, thank you very much for inviting me to be here. Now, maritime operational risk management seems to be a new word or a new coined word, but it's there from the time we get up in the morning till we go to sleep. We all do risk management in our head. But in the shipping industry, somehow or the other, we use the word risk assessment in ISM and think that's risk management. This is the challenge that we face. Operational risk management, we are not talking of financial or strategic risk management, but operational risk management comprises of risk assessment, risk treatment, which also comprises of risk reduction and risk transfer, risk review, and then the monitoring of risk. However, we try to stick to ourselves with only the ISM on the safety aspects, not looking at the overall picture of risk. Now, risk, as Leena ma'am says, that risk, and you say claims and insurance, they go hand in hand. If you don't have any claims, then why do you want insurance? Very true. Whenever we do a failure analysis, I'm not talking about the DALI because we do not know what's the cause. But very often on board a ship, when a surveyor comes, say a hull missionary surveyor comes, he wants to know what's the root cause. And we hurriedly, without thinking, give him a copy of the incident accident report. Now that's the beginning of the end of your claim. Because in marine insurance, it's the proximate cause and not the remote cause which comes into play. You are not under any duty to give a root cause analysis. You have to say what's the proximate cause. Unfortunately, most SMS safety management systems on board have only a single root cause analysis or the incident accident investigation. This should be in two parts. The proximate cause analysis and then you go into root cause analysis. This is one aspect that we have to be aware of. Now, I'm not trying to say that hide your documents. Please don't get me wrong. Utmost good faith requires you to cooperate with the surveyor. But by giving him the wrong document, you're saying every root cause, if you really do a root cause analysis, it goes down to lack of leadership and lack of management, both ashore and afloat. How many actual incident accident reports will say this? We always want to target that 80%, the seafarer. In the misinterpretation of the PNI Club statistics of 80% accidents are caused by human error is misinterpreted to mean 80% of the accidents are caused by seafarers, and that is wrong. We, all of us, included in that interest. We are all human beings. So it is from this perspective that we can't get the seafarer to be the victim of every accident. And we close out every accident report. We warn the seafarer not to commit this again, and we think that we have solved our issue. That's the unfortunate side. There is a difference between corrective action and preventive action. Corrective action has been done. That's great. But what has been done about preventive action in terms of analyzing what went wrong, and that what went wrong can be ashore as well, and how can we rectify this? So that is what risk management is all about. So what lesson can we learn from risk management as far as the DALI is concerned? It's not only the ship owner and the ship, it's the ports, it's the bridge constructors and the bridge owners. There is a report in 1982 by the government of the United States, a study on collision of ships with bridges. This 1982 document analyzes about 10 accidents of elisions with bridges, ships and bridges. A lot of recommendations have been given. Unfortunately, not a single one has been implemented. The size of ships have increased, the frequency of ships have increased, therefore the risk has increased. But what has been done to ensure that there can be loss prevention? We see the two dolphins there. Were they enough? Was a risk assessment made? Can we learn lessons now? What about the new bridge? Will it have more dolphins? Okay. So these are the aspects of operation.
Thank you, Tony sir. Thank you. Amitabh sir, you explained to us the value of this limitation, but this limitation of liability can only be useful to the ship owner if there is no fault or privity on the owner's side. Now, the authorities are obviously alleging that the ship owner is negligent and vessel unsavory, etc., etc. So that brings me to two main questions and one small one if there is time. Who has the burden of proof, and what is the standard of evidence required to actually establish this, whether the negligence in fault? And secondly, had such an incident happened in India, would the burden of proof and the standard of evidence be different?
Thank you. So I think this being a tortious claim nature, the famous Latin quote of res ista loquitur will apply. I'm not so sure what would happen in America, but at least in the convention countries, which of course includes the flag, one has to show that there was not just fault, there was knowledge, personal knowledge of the owner, which is a very difficult task, which is why the regimes have increased the limitation limits, so that you don't actually spend time in the nitty-gritties of trying to go and prove. In fact, the judgment of Justice Gupta, who was here as our chief guest, in the case of Mumang Shipping, which is the leading case in India and has been followed thereafter by other courts as well, on limitation of liability, says that so far as India is concerned and the way India has enacted the Limitation of Liability Convention, it's an absolute limitation of liability. And it is for the asking. So if this happened in India, one would go straight and file a limitation action, and it would be for the asking that you would get it, unless one was able to show that there was, actual knowledge. And in my knowledge, I've not come across any sort of case where that has ever succeeded. Or
so, sir, in USA, would they impute such knowledge to the ship owner? Would they impute it?
I wouldn't be able to tell you that because I'm not a US lawyer, but obviously the US lawyers are going to use that because they're trying to break limitation and go into it. But at least in the convention countries, that would not be, at least 76 convention countries, that would be very difficult, including in Singapore.
So coming back to the burden proof, would then...
if it has to break, if the person wants to break the limitation, will have to have burden of proof.
That be the authorities, US
authorities will have to.
In this case.
Absolutely.
And the standard of evidence is quite high.
It will be very high, yes.
In US as well.
I would imagine so, yes.
That's what I wanted to clarify.
I would imagine so. And of course, don't forget, so far as salvage is concerned, general average contribution is concerned, or any other claims which are within convention related realm or statute, those don't fall within limitation of liability anyway. So that would be beyond the limitation of liability issue.
Thank you again, sir. So, Ms. Nina, the owners promptly, I think it was within 2 weeks or 3 weeks of this incident, they declared general average, and then the reports talked about they appointed Richard Hogg Limited and as the average adjusters. So now, with all this background, can you tell us about the admissibility of this GA and the reasonableness of this GA claim, all the claims rather?
So we start with the broad categorization. We'll follow the same order. First is the physical damage. Now, physical damage to the vessel is covered as a partial loss, particular average claim, and if the damage, the matter is in the court. So, if the allegation of the owner that the damage is due to contact with the bridge is agreed by the underwriter's surveyor, then that loss will be paid as a PA loss under the policy. And under the standard policy, which is the ITC hulls, it would be 6.1.7, which is contact with any dock conveyance or a harbor equipment. Now, when we talk about the first class of perils, it's not subject to lack of owner's due diligence. So, insurance company, if they agree that the damage is due to contact, then they would pay it without looking into the lack of owner's due diligence part. Now we come to the second part, which is the salvage operations. Now, salvage carried out was a real massive task, and it was done in a very short time, and approximate figure just now before us is about 19 million, which will be contributed for by the cargo, the container, the time charterers, bunkers, the freight at risk, all will contribute to the salvage of the ship. But the salvage of the bridge, the wreck of the bridge, the removing and dismantling the parts of the bridge would fall under the P&I policy, would not be covered under the hull policy. Now, thereafter we come to the loss of profits or business interruption policy. Now, under the marine, we have a policy called loss of hire policy. Now, under the loss of hire policy, the vessel's delay due to the loss covered under the initial policy, that is a hull and machinery policy, would be paid subject to loss being paid under the H&M policy. Now, the indemnity under this policy is the per day charges, which is a pre-agreed amount, and that is paid to the ship owner for maximum 180 days with a 14 days deductible. So this is the loss which he is undergoing, and he is reimbursed that loss, but it is a pre-agreed amount. Now we talk about the ship's contribution of general average. Now the basic general average claim here is the GA loss on the ship. The GA loss on the ship is that whenever a salvage operation is done and the ship has to be cut deliberately to facilitate removal of the cargo or to facilitate removal of the bridge, all that becomes a GA loss of the ship. GA loss of cargo also could be there, GA loss of containers also could be there. Altogether becomes a GA fund. Now this fund has to be contributed for by all the property which was involved in this. So these are extraordinary expenses which were deliberately made for the purpose of saving the common maritime adventure, and when this is done, this becomes a general average loss, and it is contributed for in a proportion. Now what is this proportion? The proportion is the arrived value of the property at the destination or at a place where the voyage was abandoned. So this value is the contributory value, which is called in the GA parlance, and then the loss is divided. So this 19 million would be apportioned between all the contributing interest, how it is called. This is regarding the GA loss. Now we talk about the liabilities. When I earlier spoke about the liability part, I missed out on speaking on the oil pollution. The mitigation exercises as well as the actual removal of oil pollution, if any, in the harbour will be falling on the P&I policy. So all liabilities of the third party, pollution mitigation losses, and any other liability which will come upon the ship owner will be dealt with by P&I depending on the cover provided. I think Britannia Club is the P&I club, and they will bear these losses based on the cover provided by them. I think that's all. And the legal cost, of course, the legal cost to defend the claim, which is payable under the hull and machinery policy will be borne by the hull and machinery underwriters. And the legal cost for limiting the liability, because it's a liability claim, will go under the P&I policy, and legal cost for limiting the liability will be paid by the P&I club.
Yeah.
Yeah, sure.
Please.
When we say P, and I think you'll correct me if I'm wrong, when we say that it will be P&I or hull and machinery, of course, so far as P&I is concerned, it will be on the basis, I say this because there's this general concept that if a third party claim happens, the P&I will pay. But it is, as correctly put, depending on the P&I policy, and of course on a pay to be paid basis. The P&I is sometimes facilitated, but there is no real requirement for facilitating it, unless there are conventions under which you have, which is the blue card, where there's a direct right of action, and that depends on country to country if they have ratified the convention to have the blue card. If they haven't, then you don't have a right of action.
Thank you, sir. That's very, yeah.
Sorry.
And I want to ask you, so you can add this also in your next, please continue, but I want to ask you
Just
one.
a small thing, just to add was that there are claims from third parties, which is, just to add on that, like you have longshoremen claiming because they have lost employment, you have dockers claiming because they have not got job for a long time because of no activity in the port. All this will depend on the P&I cover. Okay. Whether the owner will be able to recover from the P&I club will depend on the P&I club.
So just one quick line required, and sorry to interrupt you. So this, the cost of actually removing the debris from the riverbed. So they use extensive side scan sonars and lidars to actually remove all. So that's part of what claim then? Just clearing the channel.
Yeah. So clearing the channel is a part of the P&I claim.
Okay.
And the bridge that is fallen on top of the
Yeah,
ship is a salvage operation.
That's a salvage operation. So actually, same part of the bridge is underwater, but becomes a different claim. I mean,
yes.
Yeah. So the
Yes,
bridge that
bridge
stayed on top, okay.
Yeah.
Because most of the the parts that fell on the ship actually stayed in the ship, and that's how they. Interestingly, what they did was they grounded the ship and put her down by the head to stabilize the ship while they removed the bridge girders. Otherwise, she would be unstable during that period. But Sanjay ji, so we've seen the role of NTSB in this, and the way they went about this. Very methodical, of course. They've called various experts from the nautical operations, engineering people, Hyundai shipbuilders, even the management were part of the team. So can you just, and the report is really substantial, about 8-9 pages of actually technical, so just decode all this for us and tell us briefly how they went about fighting the cause. I mean, so in a language that mariners can understand.
Yeah, so I'll just stick to what is written there in the NTSB report. They have, of course, described the entire sequence, and the report is actually filled up with a lot of technical jargon. And of course, it takes quite some time to understand, and you have to go back on the first page and then see how much it correlates and so on and so forth. But basically, what really they are trying to say is that this incident happened because there were 2 sets of breakers which opened up, and it is very important to note that these, in the report is written very clearly, they opened up unexpectedly. That is something which is very, very critical. They said unexpected opening of the circuit breakers, which basically led to an interruption in the supply of the power. As many people would know, and also for those who don't, this vessel Dali, this has got 2 types of powers. One is supposed to be the high power, which is 6,600 volts, and the other one is a low power, which is 440 volts. And obviously, it has got different kinds of bus bars, and it's got a different kind of an electrical control systems. So the generators are supplying 6,600 kilowatts, which is supplying to the bus bar, which is rated for that figure. And then after that, it passes through a set of breakers through a step-down transformer, where 6,600 volts is stepped down to 440 volts. So what really happened was, at one time, it was that breaker which connects the high voltage to the low voltage, before and after the step-down transformer. Those set of breakers opened up. So while as the generators were running, they were supplying the high voltage, It was the low voltage supply which got interrupted. And it is a low voltage supply which is supplying to the various pumps which are going to keep the main engine running. Now when the low voltage was absent, all the pumps to the main engine they stopped, and as a result the main engine tripped. Now after that, of course, there was the emergency generator which also started. But however, what really happens is that if there is a lack of propulsion, then the steering gear is not really going to be very efficient, which is what actually happened in this case also. And the vessel is also equipped with what is known as a bow thruster, which is a thruster at the forward part of the unit, which also I think it has been mentioned there. However, what is important is that a bow thruster will only be effective if the speed is going to be less than about 2.5 to 3 knots. Anything more than that, it is not really going to work. So essentially, the effectiveness of the bow thruster was not there. The effectiveness of the rudder was not there. So which is what actually, led to this kind of a thing. Equally importantly is the overall timing of this. You see, it is like one of those many cases where everything just tends to come all together. Now, if this had happened a few minutes before or a few minutes afterwards, maybe it would have a completely different outcome. So now, coming back to what the actual cause is, I mean, the report very clearly says unexpected opening of the circuit breakers. That means there is no reason to believe that the circuit breakers should have opened up at the time when they actually did. So if we were to define what the proximate cause would be, which is going to be very important, and of course this is not directly mentioned in the report, but I think it will be fair to conclude like this. What I would like to say is that a malfunction of the electrical system leading to opening of electrical circuit breakers resulting in cascading system failures, particularly the loss of propulsion and steering with insufficient time and distance to arrest the vessel's forward momentum before impact. The fact that this occurred in a narrow shipping channel with a large vessel carrying significant moment made recovery impossible in the available time and distance. So basically we are talking about a machinery fault here. And that machinery fault happened in an unexpected manner, and that is why, I mean, it's something which nobody could really do anything about.
Absolutely. I just want to add, Sanjay, and this is what it struck me as well, for people who do not know. Of course, the emergency auxiliary engine generator did come on load, but it's not sufficient to start the lube oil pumps and the other auxiliary required for main engine. That's important to understand.
Yeah.
Even though the emergency generator came on load, it's not enough.
Yes.
Tony sir, you in your previous discussion you mentioned this concern with due diligence and the concerns regarding ISM, and also this question about, and this is in my mind, in case, actually Amitabh said it's very difficult because the standard of evidence, but just in case there is this risk of unseaworthiness being shown, my concern is it opens up the chances of criminalization of the crew. So can you just these three things, can you please comment on this?
The word unseaworthiness means many things in many contexts. For example, in the contract of carriage of goods by sea, whether it's the statute or the Hague rules or the Hague Lisbon rules, there is a due diligence on the ship owner to provide a seaworthy ship at the commencement of the voyage, in addition to carefully carrying, stowing, caring for and discharging the cargo. Now the same word due diligence you will find in the Hull and Machinery policy. It's known as a due diligence proviso. It appears at two places. One is in clause 7, which is the pollution hazard clause, where governmental authority may destroy a ship to mitigate pollution. But that is also subject to owner's due diligence. Similarly, all the losses and the perils under 6.2 are subject to a due diligence proviso, and this includes negligence of the master, officers, crew, pilot, charterers and repairers. Now they are all subject to due diligence. Now let's assume that for whatever reason there has been lack of due diligence on the ship, or not in the Dali case, because we don't want to mix this up. I'm giving a general we can apply to the Dali later. If the ship owner lacked due diligence providing a seaworthy ship, then he has breached the contract of carriage. He has not necessarily breached the contract of insurance. And these are two separate issues that have to be looked into. So a Hull and Machinery underwriter cannot take the plea that since cargo has refused to contribute in general average, and they have been found to, it was due to lack of due diligence on the part of the ship owner, therefore we are not going to pay a hull claim. But they would have to prove, and the burden of proof shifts. The burden of proof in a carriage of goods by sea is on the ship owner to prove that he provided a seaworthy ship before he can avail of the immunity, 17 immunities in the Hague rules or the Hague bureaus. On the other hand, in the insurance policy, the burden of proof is on the insurer to prove lack of due diligence as a concurrent cause of the negligence claim. So,
it is very important.
Right. Now, let's apply this to the seafarer. Where is the question of the seafarer coming into an unseaworthiness claim? Unless he deliberately did something, an act of barratry. And an act of barratry, incidentally, is an insured peril under hull policy. Well, that's what a hull policy covers. Of course, that does not mean he's going to be scot-free. I mean, that's tantamount to sabotage and whatever legal action will be taken against him. But the innocent ship owner, the innocent in inverted commas, is not going to be penalized by that negligent act of the seafarer. However, when it comes to vicarious liability, it's another story. He's getting away with the hull policy, but he won't get away with the contract of carriage. So, I hope I've said all this right, because
if I can just add, I mean, I have this talk whenever I talk to insurers, especially cargo insurers, and I have to keep telling them that, you know, you must understand there's a huge difference between the liability that you have under your policy and your right of recovery from the owner or the P&I club. Because you have a cargo which is damaged, and there will be claims of cargo damage in this case as well. You have cargo which is damaged, let's say by fire or an incident which is insurable, and therefore you have to pay. There's no question about you not paying. But the ship owner may have a defense under the Hague rules because of fire, because of anything, and that means you may not recover it back. So in subrogation doesn't mean that I will get back what I have paid. They're two totally different insurances.
It's not a back-to-back. Thank you very much. Sir, coming back to you on...
If I may also add,
please.
not about the insurance, but about the technical part of it. I think there's been some news which is just supposed to be nothing else but just conjecture, which says that the vessel was not really seaworthy. Now, if you were to look at the past record of the vessel, it's like one of the best. During the various inspections, during the various other records which we find on the various other public domain aspects, we find there is absolutely nothing against the vessel. And so really there is no reason to believe. And it has maintained the highest category in the various MOUs which are there with the BSCs. And as far as the USCG is there, it's also maintained what the highest possible category is there. So really there is no reason to believe. And of course, if you look at the owners who are involved, I think their record has been phenomenal. And finally, I mean, you know, if we were to look at this, sorry, I have to refer to my notes because, you know, so as far as the duty of care is concerned, there is really no reason to consider this was not the case. I think if it was the case, this would definitely come to light before. And if somebody was to ask, was the vessel seaworthy or not? I think the answer is very, very clear. The vessel was definitely seaworthy, given a strong safety record and history of past inspections.
We discussed US law, and my next one I want to read out because I want to get the words right. The claimant must typically prove physical damage to property. So obviously I presume that there's a bar to recovery of pure economic losses and business interruption claims. So when the law says that they must have physical damage, is that the Indian position same?
Very much so. There's a judgment of the Bombay High Court again, which says that you cannot claim pure economic damage unless it's linked to physical damage, because it would be against public policy.
So all the one that Ms. Leena alluded to, those business interruption claims.
Correct. For example, let's say
I've lost my business, that's not going to work.
No. Against the owner would be very difficult.
Very difficult. So that means, in other words, this figure that we just been going around, definitely.
It would probably come down.
Yeah, but it includes all those.
Yes, absolutely.
Yeah. Which includes even.
But some insurance company may have to pay for that. Like as Mr. Modi said, you have higher insurance. Now, for example, because of the ship being stuck, if the time charter puts you off hire, then the owner would get paid from somewhere or the other. The money would probably come, but not. You could not possibly look at the ship for getting that.
So an important distinction here, in my mind, would be that the economic losses suffered by the bridge and the toll that they have lost because of that will definitely be a claim.
Subject to remoteness, mitigation, how long, etc. All of those criteria will come in.
Yeah, because here there's a physical loss as well as there is...
Yes, but then it would be tested against issues of remoteness, mitigation, and all the rest to actually come to the claim amount.
No, but sorry, the toll, where's the question remote? The toll is a loss.
How much toll would be lost? What would be
there
the
are statistics in the papers about
correct,
what being
as a lawyer,
national highway. So
correct. As a lawyer, one would always want to.
Yeah, as a lawyer. Yeah. But I think in this case it's very clear that toll has been lost in that
yes,
period.
but I mean, how much of it has been lost, etc. will be subject. The quantum will be subject.
Quantum. I mean, the traffic that will divert to other highways, etc.
Exactly.
Yeah. Thank you, sir. So, Ms. Dina, just few last, we've got about 5 minutes left, so just quickly run through the remaining things which is important to discuss. So typically freight forwards issue a house PL and then they are having the line of PLs with the ship owner. So can you explain to us what is the process of GA declaration and collection of security from these various entities?
Normally, after declaration of GA, notice is given to the cargo, and along with the notice, all the security documents are also handed over to all the interests, cargo, container, time charters, bunkers, and they are supposed to execute them. The security documents comprises of, firstly, a GA bond or an agreement, which is just a mere undertaking that the cargo interest will undertake to pay GA contribution if properly adjusted. It's just that much. And thereafter, just on the basis of this, the cargo will not be released. The cargo insurer will require to be given to give a GA guarantee. Now, before he gives a GA guarantee to the cargo assured, he will ask for a counter guarantee. A counter GA guarantee is asked by the insurer from the cargo assured. He will take an undertaking from the cargo assured that should the GA contribution be in excess of sum insured or not covered under the policy, the cargo assured would be liable to pay for it. That is an undertaking which is given and then only a guarantee is issued. So, cargo guarantee and cargo bond, the GA guarantee and GA bond are submitted to the cargo underwriters, and cargo underwriters then say that we have received a satisfactory GA security and the cargo may be released. So it comes to the adjuster and adjusters issue a release order. Very often we have seen that the cargo is not insured or the underwriters with whom it is insured, their credit worthiness is not acceptable to the adjusters. In such case, a cash deposit is collected. When a cash deposit is collected, the adjusters estimate the GA fund and the percentage of GA contribution which will come from the various interests. In this case, presently it is estimated to be around 55%. So 55% of the arrived value, that's the contributory value, of the cargo or the containers or freight if it is at risk, everything is collected in cash and deposited in a common account by the adjuster and the ship owner. Now, this is held to be payable towards the GA contribution which is due. It is understood that it comprises of GA loss, proportionate GA loss, the salvage charges and the special charges if any. So this is broadly how a GA transaction is dealt with by the adjuster's side. Now after all this is over, the real problem starts. It's only the real problem starts that there are so many uninsured cargo, there are so many who have abandoned the cargo, there are so many who don't want their cargo. So there's a huge amount of recoverable general average contribution. P&I is of course there to look for such losses, so they cover such losses. But for an adjuster, it's in a container ship general average, it's a massive task. You're talking about here 4,680 containers with LCL and FCL cargo, and imagine the volume of the work. With every consignor you have to send that and recover it. This is regarding the process of the GA. Now regarding the freight forward, I'm cutting it short because of lack of time. Now freight forwarders BL is a very interesting issue to understand. Now a house BL is issued to every individual consignor by the freight forwarder. And freight forwarder himself obtains a BL with his name as a consignor from the ship owner. This most of us would be knowing, right? Now what happens under the freight forwarder's liability insurance? What is he covered for? Now there are times when he also has his own containers. So it is like an NVOC, OCC. He is a non-vessel operating cargo carrier. And if his containers are there, he will be required to give GA security for his containers. Okay, so he gives us GA security for his containers. But we have seen that he is also required to give GA security for cargo. In which cases? In cases where cargo has said that no, we are declining paying any general average. You do whatever you want with the cargo, we don't want the cargo, we don't want to give GA security also. So where cargo interests abandon the cargo or decline giving general average security, in such cases, because that house BL is in his name, he has to give a security. After giving security, he also has to pay the contribution which is due and properly adjusted. So this contribution which he is liable to pay is covered under the freight forwarder's liability insurance and is paid for to the extent that he could not recover from the cargo.
Thank you, ma'am. So, Mehra Sahab, the question has been, it's reached the destination, but just give me a minute before we get back to your question. Only, sir, from a loss preventive, perspective, what are the design parameters that we must keep in mind? And one question that comes to my mind, and I'm not saying this because I'm trying to, sort of allude to, let's say, negligence on the part of the port, but it occurred to me that the tugboat actually was cast off as soon as the vessel was turned around. And thereafter there was a 10-minute passage to the bridge. So from loss preventive background and from lessons, I would imagine that if the tugboat had actually stayed alongside for just that period, small, 10-11 miles, this could have prevented. So what are your thoughts on generally loss preventive measures from this case, lessons?
From a lessons learned point of view, we can look at it from several angles. One is the bridge design itself, the future bridge design in terms of the number of dolphins to prevent it. The amount of care that has to be taken apart from the pilots with tugs. Say for example, is it not worth it to have the tug connected whilst passing through the bridge itself? But some of the good things of this also required to be a problem. The pilot's presence of mind to alert the bridge authorities, to immediately stop the traffic, saved hundreds of lives. What if the pilot was not on board? Would the master have known this? So, when a vessel leaves a port where the bridge has to be crossed, is it not worth giving to the master an emergency numbers, what he can get into in terms of mitigating of loss? It's all nice to talk about this now, but these are the ones that trigger some loss prevention suggestions. When it comes to operation of machinery, today there are condition monitoring equipment which fitted on a diesel engine or a main engine can give you early warning signs well in advance. Uday Rohit, my good friend, has Junas, and he is supplied these equipment to the Indian Navy and to Indian Air Force as well, and the Coast Guards. So there are a lot of developments. Today AI is there. With AI and monitoring of these parameters online, a lot of prevention, you get an early warning system, apart from anything. But at the end of the day, it's the human being, and that is important.
Thank you, sir. We've actually overshot by 3 minutes, but Sanjay, could you answer Mehra Saab's question?
All right. So I'll just read out the question.
Yeah, please do that. And then
Yeah, so there is a question which has been received. My opinion has been asked for on neglect on the SMS procedures not being followed when there was a blackout in port. You see, I'm very sure the NTSB must have gone into details of this. So this is probably one of the first things which needs to be checked. And they would have seen what all procedures have been issued by the company, what all records are there on board in terms of having complied with those procedures. But since it is not finding a mention anywhere in the report, so really there is no reason to believe that something like this has happened.
Can I elaborate? It's my question.
Yes, yes, please.
David sir, can I get a mic given to David sir?
Yeah.
You like to? Yeah.
Yeah, it's okay. So I'm just going by the NTSB report itself. So what was mentioned was that in port they had some crew member inadvertently shut the damper to the exhaust manifold. There was a power outage, and then they restored the power, but they changed over the breaker set to the standby breaker set. Now a practice on board is to test out the standby breakers when there is least risk, like out at sea. So inadvertently it is mentioned in the same report, they had not changed the breakers for many months, and so due to overuse, they decided to change over the breakers in port. You cannot do an operation like this in port, especially knowing you are going to have a critical maneuvering operation immediately after that. So my question is about that neglect, that they have not followed SMS procedures on board, where standard shipboard practices tell us to change over to standby equipment every 1.5 months, 2 months, or whatever the specific period. So basis that, when they did that, and those breakers failed out at sea, which is what caused, and then they went back to the original breakers after that. So I am talking about that neglect part of it, which has not been highlighted anywhere.
Yeah, absolutely. I completely understand what you are saying, but yet the NTSB report states that they are trying to ascertain why this kind of a thing was done. I'm sure if this would have been a direct aspect of not having complied with the SMS, this would have been mentioned in this report. And secondly, the point is that why did they actually do it? And even the report is also quite about what is the impact which this could have really happened. Now, again, it is probably going to be not really correct to say that if this would not have happened, then the blackout would not have been there. So, okay, maybe we can always discuss about this. But at the same time, if this would have been the case, then I'm sure this would have been explicitly mentioned in the report, which it has not been. That is why it forces us to consider and think that there are many other aspects which are involved. I hope I answered your question.
Thank you, Sanjay. So there's one last question. Pardon me, we are already 5 minutes now. So quickly, this actually is addressed to me, but I think it's best addressed to Tony sir, and because this is Tony sir's favorite question. In fact, when will India have their own Indian association of average adjuster? Look into the future and tell us, sir.
I've been shouting from the rooftops.
I know, so many years.
As a voice in the wilderness.
Yeah, so many years.
But I think it's high time.
Yes.
We talk of the Indian PNI Club, but nobody talks of the Indian Association of Average Adjusters.
Yes.
I personally feel it's the need of the hour, because Indian ship owners are at a big disadvantage today, because Indian underwriters have over the years appeared to have lost confidence in the average adjusters, and for whatever reason they feel they have lost it. They are now relying on insurance surveyors to comment on aspects of liability, which is absolutely ridiculous, because the policy says that this policy is subject to English law and practice. However, the regulator of insurance, none other than IRDAI, has made it mandatory for surveyors to comment on aspects of liability and has not differentiated between marine and non-marine policy.
Yeah, which is so unusual. It's absolutely thank you, sir. I'd like to end in a very positive note. So, a few months after this incident, I've been looking at the internet for several months now, just for my own academic interest, and I was very pleasantly surprised to see an incident MSC Michigan, which in June, while leaving Charleston Harbor, actually had an engine control failure. There, of course, the opposite happened. The ship could not stop. It accelerated up to 16 knots, and did that for 20 nautical miles, passing under 2 bridges and some 4-5 turns, and actually successfully went to sea. So you have a positive outcome to a failure as well. Thank you, everybody. You've been a wonderful audience. I'm sorry that there are no questions.
Thank you everyone. I request you to stay back and I invite on stage Mr. Rohan Janardhan, Managing Partner at Rex Legalis, to please come forward and present a token of our appreciation to our moderators and panelists. I'll request all the panelists to come ahead for a group photo, including